Good afternoon, and Gamar Hatima Tova, which means may your new year be well sealed, in honor of upcoming Yom Kippur this evening. I'm delighted to welcome everybody to our annual Supreme Court preview. I'm Lee Liberman Otis. I am the senior vice president of the Federalist Society, and this event is co-sponsored by the faculty division and the practice groups of the Federalist Society, and we're just delighted to have everyone here. I am now going to turn things over to our incomparable moderator, Amy Howe of SCOTUS blog, and she will get the show on the road. Thanks again.
Thank you, Lee. Incomparable is kind of a lot of pressure, but I know that I've got great panelists, so I am sure the panel will live up to it. It's wonderful to be here, to look forward to what is promising to be a very momentous term, the 2025-2026 term, which starts on Monday. And thank you to the Federalist Society for inviting me. I'm really looking forward to listening to all of these panelists and maybe getting a little bit of insight for the stories that I have yet to write. I'm going to start with brief introductions of our panelists, and then I'm going to move into, just to give you a little bit of a roadmap, we're going to start off with a discussion of the cases that we already know are on the court's merits docket for OT 2025. Then we're going to sort of step back and have a broader discussion of the emergency docket and the big picture, and then look ahead at what could be coming to the court in the rest of the term. And then we will leave about 15 minutes for your questions. There are a couple of, I will remind you again, there are a couple of floor mics here. So if you do have questions, please, when the time comes, go to those floor mics and we can take your questions. So some brief introductions of our terrific panelists. I would encourage all of you to read their bios to get the full, to really appreciate the full range of their expertise. But starting on my left, we have Kevin Walsh, who is a law professor at Catholic University's Columbus School of Law and a former clerk to the late Justice Antonin Scalia. Next to him, we have Michael Domino, who's a professor at Widener University's Commonwealth Law School, a former clerk to Judge Lawrence Silberman on the DC Circuit, and my favorite part of his bio, a long-suffering fan of the Buffalo Sabres and the Buffalo Bills. Next to him, we have John Richter, a partner at King & Spalding. He is going to be our specialist on the criminal docket today. He's former acting assistant attorney general at the Department of Justice in the criminal division and a former U.S. attorney for the Western District of Oklahoma. Joanne Sager is a partner at Hogan Lovells with extensive experience litigating before the Supreme Court, including getting 3 grants last term. So good luck this term. Hopefully it'll go just as well. Megan Brown is next to Joanne, is a partner at Wiley Ryan with a wide range of litigation, appellate, and Supreme Court experience, regulatory experience, including the First Amendment. She's going to walk us through some of the First Amendment cases on the court's docket. And then last, we have Carrie Campbell-Severino, who is the head of the Judicial Crisis Network and a former clerk for Justice Clarence Thomas. So we are going to start with Kevin and the merits cases. Before we do, I want to say that sometimes when I've moderated term previews, I have to pause for a second and say that, of course, what we're discussing now is only the cases that are going to be argued in October, November, and December, that the court is still going to be filling out its calendar with January, February, March, and April arguments. And so even if there aren't any big blockbusters on the calendar yet, there still could be more to come. And I don't really need to say that this year. And I was also going to make a joke about, checking our phones, since, there's always the possibility that while we were eating lunch, this court has added another case to its docket. And lo and behold, at 10:45, not actually while we were eating lunch, the court announced that it was going to hear argument in January in the Trump administration's request to be able to fire Lisa Cook while her challenge to her dismissal moves forward. So my joke's blown out of the water by the Supreme Court. So I'm now going to turn it over to Kevin, who hopefully has better jokes.
Well, okay. Thank you. And the two cases that I have both involve actually the emergency or interim docket in some way. So, and by the way, as we were prepping for this panel, we thought, who's covering the FTC case? And that came my way. So that'll be my second case, the Humphreys executor type case. But this first one is big in its own way, and it's not as high profile, but very significant. It's what I think of as a good old-fashioned, we need one Supreme Court to be supreme in the right way kind of case. So in February 2017, Jeffrey Colt was hit by a New Jersey Transit bus while in a crosswalk in Hell's Kitchen. He sued New Jersey Transit and the bus driver in New York State Court. In August 2018, Cedric Gillette was the passenger in a car hit by a New Jersey Transit bus on Market Street in Philadelphia. He sued the driver of the car he was in, as well as New Jersey Transit in Pennsylvania State Court. So two cases, two different state court systems, same defendant, New Jersey Transit Corporation. Now, in 2019, the Supreme Court held that sovereign immunity extends to states in state courts as well. So you can see what's coming. The question is, does the New Jersey Transit Corporation have sovereign immunity? And that turns into the question of whether they are an arm of the state. So they asserted this in both Pennsylvania and New York, and it worked in Pennsylvania, right? So Pennsylvania says New Jersey Transit, arm of the state. New York says no. So it's time for the Supreme Court to sort this one out. The question presented is whether the New Jersey Transit Corporation is an arm of the state of New Jersey for interstate sovereign immunity purposes. So this is an unusual case in that the first petition came out of the Pennsylvania case. So, but by the time they had filed the petition, New York had already gone the other way. So for all the people who are looking, they think, I may have a grant here, right? And it was more a question of which case would they take or not. And the petitioners were in the enviable position of having the respondent agree that they should grant cert. So all of that seemed fine. And in fact, New Jersey Transit, in their brief, sort of not in opposition to granting cert, but their responsive brief, of course, like any good lawyers, you'd start arguing the merits. And I think the way they frame the question gives you a sense of the substantive matter at issue. So here is how New Jersey Transit framed the question. They said, whether a state's formal financial liability for a judgment against a state-created entity carries more weight in assessing whether that entity is an arm of the state than other factors, including the state's own characterization of that entity. So what they're basically saying is we should win because if you get our state law characterization correct, we are an arm of the state. The way that we would lose is if you think that the factor that the state won't have to pay any liability that we're found for. If you weight that really heavily, we're going to lose. And so you shouldn't do that. You should look at how we're characterized. So let me just say, that doesn't sound like an emergency docket kind of case. So where did that come? Well, the cooperation of the lawyers to get this before the Supreme Court of the United States was not met with a similar amount of agreeableness in the New York state court system. So the New York case in which sovereign immunity was denied was set for trial, and the trial was to take place in September. And so, of course, with these pending at the court, the New Jersey Transit has been, trying to get a stay all sorts of different ways, went up, ultimately New York Court of Appeals, stay was denied, so they went to the Supreme Court of the United States, and the Supreme Court of the United States said, okay, we're going to grant the stay, we're going to hold the New York trial pending issuance of the court's mandate in this case. So that's the first case. Now the next one, FTC versus Slaughter. So this kind of case begins. There's so many ways to tell this story, but we'll begin on March 18th, which is the day that President Donald Trump dismissed FTC commissioners Rebecca Slaughter and Alvaro Bedoya, citing policy differences. Okay, so Slaughter challenged her dismissal or her removal, saying it violated the FTC Act's for-cause protection. All right, there was no attempt to comply, to say this is for inefficiency, neglect of duty, or what have you. And it's that case, that challenge to her removal, that is now up at the Supreme Court. There's a lot that we can say about how that interacted with, well, the Supreme Court potentially overruling Humphrey's executor, which is the case that would have protected Slaughter from removal. But I think that the kind of back and forth of the emergency docket kind of things, we can defer that for round two. I'll just say in round one, the questions presented, okay, as they came off of the emergency docket, Chief Justice Roberts referred a stay application to the court, and then the court granted it. And here are the two questions, right? The two questions are whether the statutory removal protections for members of the Federal Trade Commission violate the separation of powers, and if so, whether Humphrey's executor versus United States should be overruled. The second question is whether a federal court may prevent a person's removal from public office either through relief at equity or at law. And so this is scheduled to be argued in December. There's a lot more to say about that, but let's move on to some more cases.
All right, before we move on, do any of you want to respond? Have any thoughts either on New Jersey Transit versus Callais or sort of the basics of the Humphrey's executor case? I know we've got a lot to talk about with the Humphrey's executor.
Our opinions about the New Jersey Transit.
Yes. Fair. All right, Michael.
Very good. Thank you, Amy. Thank you, Lee. Thanks to the entire Federalist Society for the invitation to be here. It's wonderful to be here, and it's a very nice honor. I'm here to talk about a couple of the most exciting cases of the term, the election-related cases. In particular, Louisiana versus Callais, a redistricting case which is back at the court after originally having been argued this past March and then restored to the calendar when the court failed to issue a decision at the end of the term. And NRSC, National Republican Senatorial Committee versus the Federal Election Commission, a campaign finance case. The Callais case may be a blockbuster because it calls into question the constitutionality of Section 2 of the Voting Rights Act. The basic question of the case is the legality of a particular district congressional district drawn in Louisiana. The district is a majority-minority district. It stretches on a diagonal for some 250 miles from Shreveport in the northwest corner of the state down to the southeast portion of the state. It goes to Baton Rouge in an attempt to capture enough black voters to make a majority of the district. The case is being challenged as a racial gerrymander, and the governing standard for racial gerrymanders is that if a state draws its district lines with the predominant focus being race, then those districts are unconstitutional unless they pass strict scrutiny, unless there's a compelling reason for doing so and the district lines are narrowly tailored to achieve that purpose. In the original argument, Louisiana argued that race was not the predominant factor in drawing these district lines, that politics was, that the reason why the district was drawn this way was because Louisiana said, well, we have to create a second majority-minority district or we're going to be sued under Section 2 of the Voting Rights Act, and more on that later. But we don't want to draw it along the eastern side of the state because if we do, we're going to jeopardize one of our Republican incumbents, including potentially Speaker Johnson. And so we'll draw it in this weird way instead because we need a second district, and this is the way that we're going to draw it that's not going to jeopardize the two incumbents that we care most about. They got sued anyway. They said, take a look at the district. This district is a long, skinny district that goes on a diagonal. There's no possible way you would have drawn this district if race had not been your predominant focus. And so we don't really have an answer to that question, but we have an indication. The court restores the case to the docket and says, we want you to argue whether compliance with Section 2 of the Voting Rights Act can be a compelling interest that justifies a racial gerrymander. So there would be no point in setting that issue for re-argument if the court were to say that this isn't a racial gerrymander to start with. So I think the court is willing to come to the conclusion that this is, in fact, a racial gerrymander, that race predominated in the drawing of this line. And the question then is why? Why did you do it? Do you have a good enough reason for making race the predominant purpose in drawing these districts? The Section 2, which is the Louisiana's defense here, Section 2 of the Voting Rights Act requires states to have voting practices, procedures, and standards that provide an equal opportunity for minority voters to participate in the political process and to elect representatives of their choice. And the claim here was that because black voters in Louisiana are about 2/6 of the state, that they should be entitled to 2/6 of the districts. And so, and in fact, there was a different district court that made a preliminary determination that Louisiana did indeed need to create a second majority-minority district. And Louisiana is saying in this re-argument, you got us between a rock and a hard place. The Section 2 of the Voting Rights Act requires us to consider race to draw this second district, but if we consider race enough that we can be sure that we're drawing a second majority-minority district, then race is going to predominate and we're going to get the district struck down on constitutional grounds. So you tell us what to do. And the court is setting up the possibility that the end result might be you cannot draw a racially gerrymandered congressional district even if you're doing it to comply with Section 2. That is to say, Section 2 might be unconstitutional insofar as it forces states to use race in a way that would create a racial gerrymander. Now, that's not the only way that the court could go, and I don't want to take up the rest of my co-panelists' time discussing other kinds of alternatives, except to note that the reason that there is this apparent conflict between Section 2 of the Voting Rights Act and the racial gerrymandering precedents is because of the way that the Supreme Court has interpreted Section 2, most especially in a case called Thornburg versus Jingles from the mid-'80s. It's that case and the cases that follow it that appear to give minorities a right to nearly proportional representation of legislative districts, despite what the last clause of the section says. And if the court were to reconsider Jingles, were to reinterpret Section 2, it could certainly do so in a way that would avoid at least the most serious aspects of this apparent conflict between the Voting Rights Act and the 14th Amendment. Brief minute and a half on the campaign finance case. The case involves party-coordinated expenditures. Most of you will know enough about Buckley versus Vallejo and campaign finance law to know that campaign contributions have been held to be restrictable. The government can put a limit on campaign contributions, but generally cannot put a limitation on expenditures. However, expenditures that are made in coordination with a candidate are treated as contributions and can be limited. So I want to spend a bunch of money to support a candidate. If I just take out a billboard and say, vote for Smith, Smith is a great guy, I can do that and spend however much money I want. If I go to Smith, though, and say, hey, I want to help you, you tell me where you want this billboard and what it's going to say, and then I spend money on the billboard. Now it's no longer an independent expenditure. Now it's a coordinated expenditure, and the law treats that as a contribution, which can be limited. Those same rules that I've been using with myself as an example apply to parties as well as individuals. So if a party spends money on its own, that's unlimited. If a party spends money in coordination with a candidate, that is limited. That limitation is the subject of this challenge. The National Republican Senatorial Committee is arguing that there's no danger of corruption or the appearance of corruption when a party coordinates with its own candidate, because that's what they're supposed to do. They're supposed to be on the same team working for the candidate's election. That's not corruption, that's democracy. And so that's the basis of the challenge. The law has existed in this form since the mid-90s when the court upheld the current system, but that has been subject to pressure, increasing pressure, given the perception that outside agencies are now being favored in campaign finance law compared to parties. And so there's more pressure now to relieve parties from some of that pressure. And thank you all very much.
All right, any thoughts from our panelists on Louisiana or the campaign finance case? Joanne?
I would love to add just another note to that really great discussion of the Callais case. I think something else that's a pretty interesting wrinkle in that case is that the question presented on re-argument was directly asked and answered by the court 2 terms ago in Allen v. Milligan. And
Yes.
So, I mean, full disclosure, I was among the counsel to Milligan in that case, and every lawyer who's ever won a case believes that the opinion is brilliant and has exactly correct legal reasoning. So I'm a big believer in the majority opinion in that case. But there, the chief said very, very clearly that Alabama pressed the argument that Section 2, as construed by Jingles, was unconstitutional under the 14th and 15th Amendments, was unconstitutional in terms of its interpretation of the 15th Amendment, and also would be unconstitutional as forcing racial gerrymanders into the 14th. And the chief examined that and said, no, that's not true. Here's a bunch of precedent in which we've said that's not true before. That precedent is still right. Here's a long discussion of how it is that Congress arrived at this compromise in Section 2. And it's our belief here, speaking with one voice for a majority of the court, 5 members on one opinion saying, Section 2 is fine under the Constitution. And so I think that's awkward for the court, one, that they asked and answered this question 2 terms ago. And I think the other part of the case that's awkward is there's a lot of briefing in Callais around why it is that the court could disavow the reasoning of Milligan and the holding of Milligan. And a lot of the energy among the parties is devoted to discussing students for fair admission and arguing that worked some sort of large change in the law. But that argument is awkward too because SFFA was the same term as Milligan and featured overlapping majorities. And so the chief and Kavanaugh joined both the majority in SFFA and the majority in Milligan. And so it's kind of hard to say, at least for those 2 members whose votes I assume will be very important in Callais, that there's some sort of great change that was worked by a case that they had joined the majority in too. So interesting wrinkle for how that's going to move forward.
Yeah, it's an absolutely fascinating aspect of the case. Now, in the prior case, Kavanaugh did write a concurrence where he said, there's a pretty good argument that Section 2 is unconstitutional, but it doesn't appear to have been argued in this case. So he at least has a kind of out. And the cases that Roberts cited in the brief discussion were cases that were decided before Section 2 was amended in 1982. It's civil rights era cases up until 1980 with City of Rome. But it's still that it is very, very peculiar that the court would have said, here's our answer to the question. And I don't know whether it's second thoughts or whether Kavanaugh says, well, now's the time to consider this argument that I thought was waived before, or what the deal is. But because the court kind of went out to ask for argument on this point, it seems to me anyway, like the court doesn't consider the case to be quite as settled as it might have been right after Milligan.
Anybody else? Okay. So we have an unusually robust criminal law docket at the court this term. And so, John, can you tell us a little bit about it?
Sure. Well, there's about About 40% of the docket this year or this term is criminal in nature. Usual bread and butter, habeas, some First Step Act, some Fourth Amendment, Fifth Amendment, Sixth Amendment cases. What's interesting in looking at how this court and this makeup of justices approaches criminal cases is that it does not break down commonly in sort of what we would think of as the conservative liberal split in the way you might imagine. And so I took a quick look at the cases decided in the last two terms, and for example, there were 18, about 26%, about a quarter of all the criminal cases in the last two terms were decided unanimously, and only about 16, well, about 30, well, a little under 25% were decided in 6-3, and so. And the vast majority of those 6-3 decisions didn't break down in the conservative liberal split. So what I think that tells you is that though the issues that come up on the criminal docket don't necessarily break in the same way politically as we may see in other areas and that will be discussed today and that the court's considering. I want to briefly touch on two different cases that I think are worth watching in this first round. The Fourth Amendment case on the docket that has gotten a little bit of interest is a case called Case versus Montana. It involves a situation in which a man by the name of Case was in his home. He had a fight with his ex-girlfriend, or his ex-girlfriend had called the police, concerned about his well-being, suggested that he might be suicidal. This is in Anaconda, Montana. Mr. Case was known to law enforcement in the area and had evidently previously taken steps that suggested he was interested in suicide by cop. The police responded to this request of his ex-girlfriend. They went to his home. They knocked on the door. They basically were outside trying to see if anybody was around. He was inside for about 40 minutes, looked in through windows, knocked on the door, called out many times. Eventually, they entered, and that teed up then a scenario in which Mr. Case evidently was found and stepped out of a closet. It was relatively dark in the room. The police officer who saw him saw what he thought was a firearm in his hand. It was a black object of some kind, and the police officer fired and shot Mr. Case in the gut. So to add insult to injury for Mr. Case, he was then charged with assaulting a police officer for the threat of the actual dark object in his hand, which the record is not entirely clear was actually a firearm. There was a handgun recovered at the scene. Anyway, what the case brings to fore then is a question of the extent to which a sort of community caretaker exception exists under the Fourth Amendment. The Montana Supreme Court handled this issue and said that such an exception does exist, that basically it's judged on a reasonably objective standard, meaning that did the police officers in question have a reasonably objective basis that is something other than criminal for purposes of investigating a crime, rather looking out for the safety and to prevent harm and injury to persons. And they found in this case, this Montana Supreme Court did, that in fact these officers did act reasonably and they met the reasonably objective standard. Obviously, the court, having taken certiorari here, raises an interesting question. Why did they take this case? Because in 2006, in a case called Brigham City, the court versus Stewart, the court seemingly had decided this question. More recently, in 2021, in a case called Coniglia, the court, in passing, seemed to suggest that there might be some problems with this. Justice Thomas wrote a majority opinion, but in that case, it was police officers operating around an accident scene and did not raise the question of the home in the same way that Brigham City or this case versus Montana case does. I think what will be interesting to watch here, the court is, there's clearly some dispute internally in prior opinions as to whether and to what degree this reasonably objective standard needs to be tied to the warrant requirement or not. Obviously, we tend to think of the entry into homes as being the place where the warrant requirement applies most stringently. But here, in a circumstance in which the police are entering for purposes having nothing to do with a criminal case, does this in fact change the standard? Obviously, that remains to be seen, but it's interesting that they've taken the case, and I think, ultimately, of course, anytime the police enter someone's home and help a person out, the chances that the exclusionary rule applies, or that there ultimately is a civil rights case brought to challenge it are small. This is only going to arise in circumstances in which a crime then is somehow discovered and prosecuted. The second case that I think is interesting to watch is interesting only insofar as where it might take us. And it's a case that involves the ex post facto clause. This is the Mandatory Victim Restitution Act, and it's a case called Ellenberg versus the United States. Mr. Ellenberg committed a bank robbery sometime in the mid-1990s. At the time of the commission of the offense, the Mandatory Victim Restitution Act had not yet been passed. He obviously was sentenced to a lengthy term in prison, served that term, got out. While in prison, he evidently worked off a little bit of the restitution that had been ordered by the court. The total amount of the restitution from the bank robbery was about $7,500. He, I think, got about $2,300 credited towards it. After he was released, however, and after more than 20 years had elapsed from his conviction, he was told, so sorry, you need to continue to pay because the pre-existing Victim Restitution Act terminated at 20 years. No matter what, after the date of the offense. And in this case, obviously, more than 20 years had elapsed, and he was still being told that he needed to continue to pay. Beyond that, he was also told that he was having to pay interest, which the Mandatory Victim Restitution Act requires. So he's challenged that. The interesting thing procedurally is that the United States is agreeing with Mr. Ellenberg that, in fact, the application of the Mandatory Victim Restitution Act cannot be applied retroactively. And so amicus counsel has been appointed. Former U.S. Attorney John Bash will be arguing for the United States, really, in the case. I point this case out in part because not because this is obviously a case that's readily capable of repetition given the elapse of time since the passage of the Mandatory Victim Restitution Act, but rather because this dichotomy between whether something is civil versus whether something is penal in nature is what drives this. If the court decides that the Mandatory Victim Restitution Act and restitution under that act is penal in nature, a criminal penalty, the ex post facto clause applies, and it can't, and therefore it's barred. If it decides it's civil in nature, then obviously it can be applied retroactively. The reason this is of interest to me is that the dichotomy between penal and civil and the implications for and its implications also arises in the line of cases that come out of Apprendi versus New Jersey, and Blakely, which obviously stand for the proposition ultimately that criminal penalties can only extend to the degree that they were proven, found by a jury or admitted by the defendant. And so if, in fact, there are at least two justices, Sotomayor and Justice Gorsuch, who have complained that, in fact, restitution, like criminal fines, should be considered criminal in nature, and therefore should, and presumably, therefore, Apprendi and its progeny should apply. And so I think it's worth watching this case to see whether this then gets decided and a finding is made that it is criminal, that the Mandatory Victim Restitution Act is criminal in nature, therefore ex post facto clause bars it, and whether that then is used to arm these justices in their efforts for a future case to apply, to render restitution as also criminal and therefore subject to Apprendi.
Thanks so much. Anybody else right now? All right. Yeah. Joanne is going to talk about two pairs of cases. One is a pair of cases called Rutherford versus United States and Carter versus United States involving the Sentencing Commission guidelines. And then a pair of cases that were not on the merits docket when we did our planning call not that long ago, but as happens these days, are now on the merits docket, the tariffs cases.
Yeah, so super interesting to hear about the court doing more criminal con law. I feel like that's been really missing from the docket for a while, so super cool. One thing that the court has been doing in the criminal context pretty regularly is it feels like there's a First Step Act case every year. The First Step Act was a statute that was enacted, big bipartisan crime reform. Did a lot of things. It's a statute that did a lot of things, one of which was to create a lot of retroactive changes with respect to sentencing guidelines and with respect to sentences, mandatory minimums, and how long somebody might be in prison for various drug-related offenses, gun-related offenses, all kinds of things. And so the Supreme Court has just kind of been sorting out case by case, term by term, the details of the statutory regime. And this case is very much of a piece with that. Under the compassionate release statute that was part of that big reform, a court can reduce a prisoner's sentence when there are, quote, extraordinary and compelling reasons for doing so. The First Step Act, as I mentioned, lowered a lot of mandatory minimums, and the question presented in this case focuses on a situation in which the defendants had been sentenced originally to very long sentences that were based on mandatory minimums, in the neighborhood of 40 years. And after the First Step Act reforms, they would have been sentenced to something more like 20 years. So, like half of the time they had before, and what is functionally ends up being a life sentence for many people. If you're sentenced to 40 years when you're in the middle of your life, like you're going to die in prison, and if you were sentenced to 20 years, alternatively, you might get out. So really big deal. And basically the question in the case is whether that type of change could be something that's an extraordinary and compelling reason. And it's an interesting question analytically because the reasoning of the court, of the Third Circuit, the court that reached the opposite decision below, was that it couldn't possibly be the case that this is what Congress was talking about because the First Step Act had several sections that explicitly made things retroactive. So if Congress said, we're going to reduce sentences and make in these particular circumstances those changes retroactive, and then it said, oh, and also if there are extraordinary and compelling reasons that somebody should be released on a compassionate release basis, Congress viewed those two things as mutually exclusive categories as opposed to overlapping categories, which is what the defendants are urging the court to say now. And the other wrinkle that makes the case interesting is that there's been a bit of a theme in the court's First Step Act jurisprudence, which is that the court has suggested that ordinary default rules apply, that the First Step Act was important and it made a lot of changes, but we've all been doing sentencing for a very long time and we understand how sentencing works, and unless Congress was very explicit about wanting to change the default rules around sentencing, we're going to apply those default rules. one of those default rules is that at resentencing, judges generally have a ton of discretion to consider all kinds of things, and there's basically nothing that tends to be off the table when it comes to sentencing. The channeling of discretion exists, and judges have to explain themselves, but they can consider pretty much anything. And so it would be unusual if a judge could not consider when sentencing someone that comparable people who had committed comparable crimes in comparable contexts had gotten a significantly lesser sentence. And so those are the cross-cutting tensions here. There's kind of just the ordinary way we interpret statutes, which is when Congress says one and also another, they mean that those two things are separate categories, versus the view that generally when we're talking about sentencing, judges just kind of have a slush fund of discretion, and we trust them to make the right decisions about how to sentence people appropriately. So that's one set of cases that should be interesting. The other set is one that y'all have heard about quite extensively, the tariff cases. I can give you a kind of broad overview of the legal version of it, because I'm sure the practical consequences and the factual background are all things that we've heard about extensively in the news. The legal arguments have focused on the International Emergency Economic Powers Act, IEPA, I think is what everyone's calling it as shorthand, and it authorizes the president to regulate the importation of any foreign property. And that authority can be exercised, as the name implies, during a national emergency. So that's why it's the Emergency Economic Powers Act. And after the president has declared a national emergency, IEPA authority can be used to deal with unusual and extraordinary threats to the national security, foreign policy, or the economy of the United States. And the president, in this instance, used IEPA to impose drug trafficking tariffs on basically all goods from Mexico, Canada, and China, purportedly because those countries had contributed to the flow of drugs into this country. And second, the president imposed reciprocal tariffs on basically every other country because he was trying to address the negative effects of large and persistent trade deficits. There are a lot of arguments that the parties make in the case. It's kind of one of those cases where everyone's saying everything all at once. I think that the arguments are going to focus on one particular argument, which was maybe the best argument that the people who are being regulated have to offer, which is that the question of whether the power to regulate imports encompasses the power to impose tariffs, which are slightly different things, arguably. The challengers say that the president's power to regulate imports doesn't encompass this power because IEPA conspicuously omits any mention of tariffs. It says that the president can regulate imports, but doesn't say that the president can impose tariffs on those imports. And every time Congress has expressly given the president power to impose tariffs, Congress has actually said, I'm giving you the power to impose tariffs, and it has imposed really strict sort of temporal and subject matter restrictions around that. It tends to be a very specific grant of authority and power, and in this case, IEPA is very broad and unspecific, and so the challengers say this is really different from every other circumstance in which we've agreed that the president could impose tariffs. And the government's primary response is that the greater includes the lesser. So if you have the power to regulate, that is to control or adjust by rule, the import of goods, you also have the power to impose tariffs on it, because that is one way in which we regulate, and everybody understands the ordinary meaning of the term regulate. And the government relies on really, really old but very foundational authorities like Gibbons v. Ogden, just fundamental understandings of the president's powers and the Congress's role and what exactly it means when the president has the authority to do something. There are a lot of other arguments in this case. I mean, I think I'll just kind of go over broad strokes of them. You know, there's a question of whether there was an unusual or extraordinary threat. The president's reciprocal tariffs were based on this idea that there's this national deficit, but that tends not to be unusual because that has been the case for many years, that there has been this deficit, so it's hard to kind of get to unusual in that context. And then there's also the question of whether even if the president could impose tariffs, could he do so in the kind of specific broad way that he did, as opposed to making narrow adjustments at the margin. Perhaps there's some lesser power that the president had as opposed to a greater one. Then there's this separate statute that's involved, Section 122, and Section 122 of the Trade Act says that the president can't increase tariffs by more than 15%, and that the tariffs can't last longer than 5 months without congressional approval. And so there's a question of whether this power that the president is asserting under IEPA is actually running afoul of a completely separate statute that actually does use the word tariff. So there's a question about whether the major questions doctrine applies here, which is actually a very interesting question. Nobody's ever tried to apply that directly to the president before, but there may be some good reasons to do so. Suffice it to say, there are many arguments in this case, and it should be an interesting one to watch.
So really simple and straightforward. Other people with thoughts? John?
Two quick observations. One, with regard to the Rutherford case, I think what's interesting about, of course, all the sentencing and sentencing authority judges is judges, of course, always have looked at proportionality. In any kind of conspiracy case, any kind of case where you've got a cooperator or someone's been sentenced first, they're always going to look. So if they know that the badder guy has been sentenced and got, 120 months, and the government comes in and says the less culpable defendant who went to trial, there's plenty of judges who are going to say, I know you government want to give award a trial penalty for putting you through all this work, but this guy's just less culpable than the guy I gave 120 months to, so I'm going to find a way to give him less time, even if you've loaded up the sentencing guidelines analysis to take you there. That's pretty, that's obviously a practical reality that informs that. And then secondly, on the tariffs case, I will say that of all the cases being watched worldwide, that's the #1 case that all foreign governments are looking at. Not to say that the rest of these cases aren't important.
They're not watching Humphrey's
but
executor?
But I doubt a lot of them are watching Humphrey's executor. And so I know that, in my trade partners are basically every company, every foreign company and every foreign government is looking and saying, are these tariffs going to hold or not? Which obviously then raises some significant policy implications for the leverage and credibility of the United States should the court strike them down.
I'll just tack on, I think the IEPA issues, you did a very good job with that case. It was the one I did not want to get because there's so many things in it. I'll be very curious to see how the court approaches it. But fun fact about IEPA, it's like a not often used statute, but when it is used, it's sort of plucked out. And there's many times when we, in advising clients, have had to write memos saying, yeah, there's no real case law saying what IEPA does, but we don't think that there's a really good basis to challenge what the president did because it's one of these statutes that gives a lot of authority, or at least it purports to. And the DOJ has new rules that are based on IEPA. So I'm really curious to see what the court does and which of the many doctrinal threads they pull, because they could really fundamentally change what IEPA has been thought to do. So I thought you did a great job with that.
All right. And Megan, you want to
Sure.
move us on to the First Amendment?
Sure.
now,
So
please.
I have 3 cases, 2 that touch on the First Amendment and 1 that's a copyright case that I think actually is super interesting and has some interesting threads underlying it. So I'm going to do the First Amendment cases first. First one, there's a lot of firsts. First Choice Women's Resource Centers versus Platkin. This is out of the Third Circuit. Oral argument has not been set yet. It's basically a dispute between a pro-life medical nonprofit and the New Jersey Attorney General. The caption suggests that it's super controversial and it's about abortion, and it's not. It's at its heart a fundamental fight about, whether the target of a government investigation who receives a very broad subpoena that appears to be at least partially motivated by the expressive activities or the associational activities can seek a federal forum under 1983 to protect their First Amendment rights. So here, you've got this First Choice Women's Center. It's a pro-life center. New Jersey's Attorney General opened an investigation into them, claiming to be investigating various kinds of fraud, such as misrepresentations to the donor base. They gave a very, very broad subpoena that sought donor identities and 10 or so years of internal communications and external communications. First Choice resisted this. They claim that this request for donor identities, as well as what they believe is kind of a fishing expedition into their communications and advocacy strategies, has a chilling effect on their rights to associate and rights to free expression. So they resisted in state court, but they also filed a 1983 case in federal court. The state attorney general, not surprisingly, contends that they have broad investigative powers to protect the consumers of New Jersey, and that the state forum is perfectly adequate to adjudicate First Amendment concerns. I will note that there has been a lot of kind of tortured procedural wranglings as the AG and First Choice have kind of battled it out. For a while, the state AG hadn't sought to enforce it and sort of throw the, get First Choice really on the hook, and there have been negotiations, as often happens with AG subpoenas. So for a while, this was a pre-enforcement kind of federal challenge, but they'd have gone to the state court and sought enforcement. But the AG says, even though the state court's not going to address their First Amendment concerns right now, and they have to produce all these documents and all this information, we can wait, and their First Amendment rights can be dealt with later. First Choice, not surprisingly, says that is a terrible situation. I have to comply and be chilled and may never get my First Amendment claim adjudicated. The Third Circuit affirmed the federal district court's dismissal. The Third Circuit said, sorry, First Choice, your claims are not ripe because you can continue to assert your First Amendment rights in the state court, even though the state court had not reached the First Amendment claims. So First Choice is faced with having to produce these documents and essentially kind of forfeit their First Amendment rights or wait. There was a dissent. Judge Bibas dissented and wrote that the state's demand for donor information without substantial evidence of wrongdoing is a direct threat to the freedoms that form the bedrock of our democracy. He would have found the case ripe and covered by Americans for Prosperity versus Bonta, in which the Supreme Court struck down a California rule requiring donor disclosures to that state's attorneys general under the First Amendment. So kind of what's at stake here? The case addresses this frequently recurring dispute that often doesn't get litigated by corporations and trade associations because they have to deal with the regulator they have and try and put the investigation to bed. So not surprisingly, there are a lot of amici in this case. One is the U.S. Chamber. We represent, full disclosure. They, not surprisingly, support the availability of a federal forum under 1983 to rein in and push back against what they consider to be abuses of state investigative power. The Solicitor General, and this is a theme in all three of my cases, and I think a lot of our cases, John Sauer is a very busy man this term, and for all the big cases that you see in the news, but also there is a very active amicus practice of the SG right now, both invited and not in these cases. So the SG is in this case, filed in support of the Pregnancy Center, framing the case broadly as about the ability to protect constitutional rights in federal court without having to pause your rights or duke it out in state court and then possibly be left without a remedy. He writes, Section 1983 provides a cause of action to parties challenging state subpoenas, and the decision below would create a preclusion trap for recipients of state subpoenas. Basically, sue in federal court before the state court orders enforcement, and the suit's unripe, or sue after, and your suit's going to be precluded under res judicata principles. So I think this is a super important case to watch. A lot of trade associations, the brief that the Chamber filed says, right, the number of politically motivated investigations is exploding at the state level. And so I think this is a really important place for the Supreme Court to at least give clarity that you can, if you can seek a federal forum to protect your constitutional rights. The second First Amendment case that I have is Chiles versus Salazar, and this is out of the 10th Circuit. Oral argument has been set, and it is next week. This case is the challenge to Colorado's minor conversion therapy law, which regulates the counseling of minors by state licensed professionals. Kaylee Chiles is one such professional, and she has sued, arguing that this state law, which is a ban on so-called conversion therapy, violates her First Amendment rights. The issue here is whether this ban on conversion therapy violates the free speech clause because it is a viewpoint-based restriction on speech. So what does the law do? I'm not going to read it to you, but I'm going to paraphrase what the 10th Circuit said. Colorado prohibits any practice, ... to change an individual's sexual orientation or gender identity, ... to eliminate or reduce romantic attraction or feelings towards individuals of the same sex. So it bans counseling to reduce same-sex attractions, which Chiles says is part of her faith-based approach to counseling, consensual counseling of minors. But the law, the 10th Circuit said, exempt, quote, assistance to a person undergoing gender transition. So Chiles' position is, you're violating my free speech rights, Colorado, because this is viewpoint and content-based. She can counsel in one direction, but she can't counsel in the other on pain of license revocation, fines, et cetera. Colorado, not surprisingly, defends its law as necessary and appropriate to protect minors from what it has deemed a harmful medical practice, right? So it argues that this law, and it's doing a frame shift, and I think this is a good example of wildly different questions presented in order to try and get the doctrines that they want, right? Colorado argues this law regulates professional conduct. This is not a speech thing. This is professional conduct. We've regulated the medical profession for decades. This is a procedure. This is a treatment, or treatment, not procedure. So this is just not a First Amendment issue. The 10th Circuit upheld the state law. It treated the law as a regulation of conduct, not speech, so therefore it subjected it only to rational basis review. The petition says this, deep into circuit split. You've got some courts who treat counseling conversations as conduct and others who do not. But there's a lot of doctrinal things going on here. Judge Hartz dissented. He says the majority erred by treating this speech restriction as incidental to a regulation of conduct. A restriction on speech is not incidental when the restriction is imposed because of the expressive content of what is said. So I think here it'll be very interesting to see how the court approaches this and sort of what is Colorado really doing. So sort of what's at stake here to wrap, Colorado wants rational basis review, and this is always kind of the big issue in First Amendment cases, is how do you frame what the state is doing to get the lesser level of scrutiny if you're the government. So Colorado wants rational basis. This is just professional conduct, nothing to see here. Chiles wants strict or at least heightened scrutiny. They argue that this impact is not incidental. The SG has filed and has been granted time and arguments. So the SG's office will be at the podium next week. The SG says that strict scrutiny, which obviously is the highest standard under the First Amendment, strict scrutiny is what should apply here, and that this speech, this law restricts her speech based on its communicative content. Not surprisingly, dozens of amici. I commend many of them to your attention. If you want to go to SCOTUS blog and poke around, you can find lots of amici. I did find Professor Volok's brief to be interesting. He doesn't take a position on which level of scrutiny applies, but he wrote specifically to say that it's a mistake to say that this is incidentally burdening speech. He says it is targeting speech precisely because of what it communicates. I will just note from a tactics perspective, right, as with all First Amendment cases, the court can do a lot of different things. The SG suggests that Colorado can't meet a heightened scrutiny burden, but also invites the court to send it back to the lower court and basically say, you messed up on applying rational basis. This is speech. Go figure out what happens to it under heightened scrutiny. So I think that case will be super interesting because the First Amendment doctrinal issues are always, interesting to me. And then I want to find my third case. And sorry, Amy, if I'm going over time.
We're good. Thanks.
Cox versus Sony Music. So this case comes to the court from the Fourth Circuit. There was a lot of press because a jury awarded Sony about $1 billion in damages that Cox needs to pay under a theory of contributory responsibility for copyright infringement. So the central issue here is whether an ISP, an internet provider, can be held liable for materially contributing to copyright infringement based on its receipt of a bunch of notices from copyright holders that, there's copyright infringement going on your network. Cox argues that it should not. Cox says, unless we're actively encouraging or facilitating with the purpose of furthering the infringement, you can't hold us responsible, right? We have 6 million customers. We get lots of these form notices. This should not be the standard. Sony argues that Cox should have taken more steps to battle this, and they say they received 160,000 notices of infringement. The fact that they didn't do more shows that they should be on the hook. The Fourth Circuit affirmed the jury's finding of willful contributory infringement. And so that's what's up at the court now. It's an interesting question of the actual Copyright Act and what is required there. There's a policy sort of sounding argument in a brief we wrote that talks about the harmful effects on the internet and digital economy if this is the standard. because a lot of ISPs say, we can't possibly be on the hook for 150 grand per infringing work, so we would have to take what sound like very draconian measures to shut off internet access upon receipt of a takedown notice. And that's going to be a real problem. Sony kind of poo-poos that and says that's not really so bad, but it seems plausible to me that there'd be a lot of overcorrection and potential interruptions of access. The SG, again, in my theme, is here. The SG was asked to weigh in by the court. It filed a brief in support of Cox, and the thing I found really interesting about the SG's brief is they go with the copyright, they apply sort of the Copyright Act, and they go through the material infringement, but they have a discussion that I think is a broader underlying thread here that I think has potential interest in a lot of other cases. There are lots of regulations that plaintiffs and regulators want to apply secondarily, right, to platforms and online services for the bad acts, let's call them, of users of those services. Usually secondary liability has to have a very clear textual sort of command or basis. So the SG says there is a broader problem of identifying the circumstances in which it's just to hold one individual accountable for the actions of another. And then he cites Grokster and the recent Twitter terrorism case as confirming that ordinary merchants can't be held secondarily liable unless there's evidence that that merchant consciously and culpably participated in the misuse. So I thought that was a very interesting statement that will have a broader tail to it, given some of the other online platform type issues that are percolating in the courts. So those were my three, and I found them interesting, and the SG's in all of them. So there.
A lot to think about. Does anybody want to comment before we move on to Carrie?
Maybe I'll just add that the First Choice Women's Center case that you mentioned, here's what it has in common with the New Jersey Transit case, which is that so that stay that they were seeking for the trial, right? The basic claim is we have sovereign immunity, so it is not capable, we can't get full relief if we have to go to trial, right? The state procedures themselves are part of the burden on the right. And I think we see that too in this First Amendment case, the First Choice, because the idea would be, no, it's totally empty to have to vindicate your First Amendment right in the state forum when that consists of being subjected to the very burden that you're trying to avoid through your federal court litigation. Yeah. And so it seems that this will be one of those cases where the definition of the right kind of emerges out of the jurisdictional procedural wrangling, and that's fascinating.
Yeah, it's a cool case.
Okay, Carrie.
Great. So I have one case that is probably going to feel like it's one of the more boring cases, and a couple that are going to feel like some of the more exciting cases. So first, let's talk about the exciting ones, the ones that have gotten a lot of coverage, and that is the transgender sports cases. So there are two cases the court has taken cert for this term, one coming out of West Virginia versus B.P.J., and then another out of Idaho called Little versus Hecox. And both deal with cases where there is a male athlete who identifies as a female who wants to compete on a women's sports team. And both of these states are among the 27 states that have laws that prohibit this. In West Virginia, their law specifically says that biological females only may compete on women's teams, but if you're a biological male, you compete on male or co-ed teams only. You can't compete on women's teams. Women actually can compete on male teams or on co-ed teams. So the law itself recognizes what I think most scientists would acknowledge, that there is a distinction between the way that men and women are able to perform in athletics, and I think common sense, and anyone who's a mother of a female athlete, or frankly either athlete, can probably attest to that as well. And this is a similar law, again, in Idaho. It's the policy that's now been adopted by the U.S. Olympic Committee, the NCAA, and the World Athletics, which is an international track and field organization, and that's in both of these cases involve track and field athletes. So the facts are slightly different in each of them, in that in the West Virginia case, we have a high school athlete who actually has been involved in this litigation since middle school, whereas in Idaho, it's a college-level athlete. And the decision at the Fourth Circuit in the West Virginia case involved both Title IX and the Equal Protection Clause. While they both were involved in the Idaho case, that was really just decided on the Equal Protection Clause. So in a sense, the West Virginia case has more of the pieces involved here, which is important because there's a chance that the Idaho case is going to be dismissed and the court will not consider that. Let me just quick give you the rundown on what was going on in West Virginia, and then I'll talk about the likelihood of what happens with the Idaho case. In West Virginia, we had a circumstance where, though the district court said that men and women are distinct and they're not comparable with respect to sports, the Fourth Circuit disagreed 2-1, and they said that this law discriminates, facially discriminates on the basis of transgender status. Now, it's challenging because Title IX prohibits discrimination on the basis of sex, but in and of itself, it contemplates distinctions on the basis of sex. And so the court's going to have to grapple with the idea of what are we really looking here? Are we looking at sex, or are we looking at gender identity? And in a law that facially doesn't address gender identity, can that nonetheless be discriminating on the basis of gender identity? This loops in a lot of questions that the court has not come to a complete conclusion on, but that other circuits have, including, first of all, whether the concept of sex is something that's objective or subjective itself. The Supreme Court has talked about it as an immutable characteristic and as a obviously protected class, whereas there are now several circuits that say have basically approached it as if it is that sex itself is a subjective and or mutable characteristic. So that's going to be one potential area to go. But the biggest question for how we analyze this is transgender status going to be considered a quasi-suspect class? That's something that the Fourth Circuit and the Ninth Circuit in these cases did find. That's a split with the 10th Circuit and the 11th Circuit, so that this is obviously part of the justification for the Supreme Court taking it. And the Skermetti case last term, we have 3 justices on record, Justices Barrett, Thomas, and Alito, saying, no, this is not a quasi-suspect class, whereas the other justices didn't really weigh in. So we don't have a critical mass yet of 5 justices saying yes or no on that, although I think, there's... I think there's reason to suspect that they're not going to want to add another quasi-suspect class to the mix, but we will see. And then also in the mix, and of course that would be really relevant to the Equal Protection Clause analysis. How are we looking at this in the Equal Protection Clause? But we've also have Title IX to deal with, and that is all happening, and really both of them are happening in the shadow of the Bostock case. It was telling that Justice Gorsuch didn't have any comments, didn't write in the Skermetti case last term. It may be a little harder to avoid some of the comparisons with Bostock in this case because we're dealing with another civil rights law here. However, certainly the parties are making arguments that Bostock isn't the right framework to approach this. Obviously, employment and education and sports are different contexts, right? There is, you could say there's not a distinction for the most part in how men and women are going to perform in the workplace, except for maybe in unique positions. But in terms of sports, there always has been understood that there's a distinction between men's and women's teams. That was contemplated when Title IX was passed. It's been contemplated since the initial regulations. There's also the distinction where this is a case that involves, encroaches on traditional state regulatory areas in terms of regulating these kinds of things. So we might expect that there needs to be a clearer indication if they're going to overturn a state law in an area that states are normally supposed to be the relevant authority in terms of federalism principles as well, because it's a spending condition. You don't get federal funding if you're not compliant with Title IX. That also one would argue that, okay, you need to have a very clear condition then if it's on federal funding. And I think, there's also been the argument that sports are being divided not based on gender identity, but based on sex because of the specific sex characteristics. So that said, obviously there's arguments that are going to be parallel to Bostock that are going to be brought. So I think it's going to be very interesting in particular to watch Justice Gorsuch? Is he going to make some commentary in these cases? Is he going to continue to at least be silent and simply vote? But the court's going to have to address that. Now, with respect to the potential mootness issue, we have the litigant in Little versus Hecox, Lindsay Hecox, who now is attempting to get the case dismissed, arguing that Hecox is not going to be playing or not going to be running track and field at Boise State this year, and they'd like to have the case dismissed. Also, I think, as anyone can understand, the level of scrutiny and public pressure that's going on in the middle of being in a Supreme Court case apparently is part of the rationale for let's just dismiss this case. That is being pushed back on by the Idaho litigants, partly because, look, we've spent a lot of time already on the case. The motion for voluntary dismissal came just 10 days before their opening brief was due at the Supreme Court, during a period in which the whole case had been stayed already at Hecox's own request, that no further action was supposed to be taken in the case. And so they're saying, look, dismissing the case, even voluntarily, is further action. And there's a question as to whether it makes sense to declare mootness because this term, Hecox says, will not be participating in sports, because there's a history in the case where Hecox has taken leave of absence from school and said, I'm not running track, but actually I'm going to join the women's soccer team. It was on the women's club soccer team. And so there's this obvious capable of repetition kind of thing and voluntary cessation questions that could argue for this case. It makes sense to continue having it. If the court did decide to allow it to be mooted, I think most of the case would still continue. The one real distinction I could see between the two is that in the West Virginia case, that student has not ever gone through puberty, and in the Little versus Hecox case, that student has. And so to the extent that that's going to matter to the Supreme Court and how they decide the case, it would be helpful to have both of those before them. And then quickly to the other case that I think fits actually really well into the who decides question. It might be a mirror image in some ways of the first choice case. This is the Chevron versus I think it's pronounced Plaquemine Parish case. And this has to do with whether a lawsuit against Chevron and many other fossil fuel companies can be brought in can be removed to federal court or must stay in state court. This arises out of a 1980 law that Louisiana passed regulating the drilling industry, and it had a clear grandfather clause saying this isn't going to apply to activities before 1980, at least if they'd already been lawfully commenced or established before that period. But some enterprising trial lawyers are bringing lawsuits nonetheless in several Louisiana parishes, saying that action not just before 1980, but 40 years before 1980, during World War II, that some of the drilling to produce gas for airplanes being used in the military was violating, because they were drilling so quickly, because the military was breathing down their neck to get more gas, that was departing from the typical rate at which they would drill, therefore wasn't lawfully commenced or established, and therefore isn't covered by this grandfather clause. It could be a windfall for these counties if they succeed, and so far it appears that the state courts are actually open to these arguments, which I think are kind of a stretch in terms of the grandfather clause here to push it that far back. But there is a federal removal statute which may apply here, and Chevron understandably wants to move this into a federal forum where they think they're going to get a more fair hearing. The challenge is that they don't have at least as to this gas, they don't have a direct contract with the government. If you're a government contractor, then you can remove it to a federal court. But in this case, the removal clarification says if it's for or relating to any act under such office. And so this is relating to the work they're doing for the federal government. And the Supreme Court has said before that's supposed to be very liberally construed and is in a broad phrase. So the question is this part of the U.S. military effort sufficient to bring it into federal court, where I think there's an argument that you're going to get a much stronger, thus far in the case so far, because some of these cases have proceeded in federal court as well, and you've got the federal judges not looking so kindly on the idea that 1940 can be covered by a 1980 law. So with that, we can go on to Thank you.
Anybody have any comments on either set of cases? Okay, well, we still, what we want to move on to next is sort of to step back and take a look at some of the broader themes. And in particular, we've just spent a little over an hour talking about the merits cases, the cases that the Supreme Court is going to be hearing when the justices return from their summer recess. But I kind of feel like if you said to the justices, return from your summer recess, they would say, what summer recess? Because they've been really busy with the emergency docket. The emergency docket has been, there's been a pretty steady drumbeat on the emergency docket since 2017. But this year in particular, it has been extremely active with a sort of steady drumbeat again of requests for emergency action from the Trump administration, which has been highly successful at the Supreme Court in getting emergency relief. So I want to just throw out a couple of really broad questions for our panelists. And from the justice's perspective, from the Supreme Court reporter's perspective, is it always going to be like this? Like, is this sort of the future of the emergency docket? Is there an end in sight?
Well, I think there are some understandable reasons why we're seeing more emergency cases now, partly just because we're seeing a whole lot more litigation challenging administrative action than we ever had before. If you look back, I think it took a big uptick during the first Trump administration. It took another, continued during the Biden administration. The fact that you're getting so many challenges to executive actions, I think it speaks to the importance of the role of state AGs in particular, but it's not just them. It's a lot of other groups that are trying to make sure that federal government is staying within its boundaries from either side of the aisle. And so as that increases, you're going to have more opportunities for courts to have to answer the question of, do we stay these actions or do we let that litigation or let legislation or executive order or regulation or whatever it is ride while we're going on? And so it's not surprising that we've had this question come up so much more, and that every time it comes up, because the idea of staying a federal action is so significant, you're going to have the court having to weigh in on it, on the emergency docket. So the fact that they're having to take more cases really isn't, I think, is just a downstream effect of this litigation. I think there's also, a lot of concerns that some lower courts are overstepping their bounds, and to the extent that lower courts are granting more of these stays than they have historically, then that pops up to the Supreme Court more often as well, and they seem in a few of the cases certainly to be a little frustrated that the lower courts don't seem to be getting the hints they're dropping, and maybe they're starting to drop more explicit explanations as to what they're doing as a result. But I think as long as this type of litigation continues, we're going to probably continue to see the emergency docket have to deal with it.
I mean, that being said, the court can resolve some of these questions in the next, I don't know exactly what the right period of time is, but some of the more novel and aggressive district court orders and the different kinds of relief that are being chosen by the district courts, maybe in a year we've resolved a lot of those questions, which are quite novel right now, and I think the court will have a chance on the merits of a few of these, right? Like Kevin talked about the Humphreys executor issue, a lot of frustration over the summer about why is this always being done on the emergency docket? And it's like, well, that's the procedural posture in which it's presented, the relief being, reinstating a federal official to a job that might have a security clearance attached to it. Like, some of these are kind of extraordinary, and so we may know a lot more at the end of the term about what the scope of proper district court relief is, and then this might calm down a little bit, perhaps.
I think also the court has recently indicated that it thinks its shadow docket orders are precedential, which is not something that I think anyone really thought until this summer. And so to the extent that a lot of the activity on the shadow docket was duplicative, cases that raised effectively the same arguments with respect to a slightly different federal official that had been removed from a position that they, could not be removed from unless Humphrey's executor was overruled. And once the court kind of indicated it wanted to overrule Humphrey's executor, it apparently, at least some members of the court, seem to think that lower courts should then, I guess, craft their decisions to respect the indication on the shadow docket of what the court might want to do. And that, I think, was news to many lower court judges. And so if it is in fact the case that the court thinks that the orders on the shadow docket are precedential, then the lower courts will start treating them as precedential, and then maybe there will be fewer applications for stays.
It seems there's this weird question of what is the law in these things, because even if it is precedential, right? So the Humphreys executor is a good example, and we haven't gone into it in too great detail, but there's been a lot of movement since, say, 2010 when it comes to the question of what is the scope of the president's power to have essentially unrestricted removal power, people who are exercising executive power. And that, the Supreme Court doctrine has changed on that, but each time they've done it, they have said, we're not disturbing Humphrey's executor, we're just declining to extend the exception to our general rule that the president has this power. We're declining to extend it to a new circumstance. So even if you have someone who's not in the FTC, who is, you're actually not going to get back into your job, the lower courts always say, well, there's this other rule that says we can't get out in front of the Supreme Court and treat a case as implicitly overruled. And one of the kind of unknowns in answer to this question of what will happen to the emergency docket is, how does this affect the Supreme Court justice's conception of the judicial power? Because the idea that a Supreme Court precedent is kind of like vacating the old rule and putting a new rule in place or something like that. It seems like quasi-legislative, right? Rather than discovering what the law is and saying what it is all along. And this question of, can lower courts get out in front of overruling? What is the difference between sort of undermining or not following a case versus narrowing it? All of these things, I think we don't know how the justices themselves sort of will react to that. We're kind of seeing it play out in real time. I, for one, would like to see them a little more open about inviting lower courts to give their best reading of the law, even, and not to treat their decisions as if they were regulations or rules or something like that, but as explanations for their decisions rather than reading them like legislation or regulations. Whether they do that or not, who knows?
I'd like to raise a couple of points that might be implicit in what's been said already. The first is that one of the problems, practical problems, with universal injunctions was supposed to be that it pushed so many cases to the emergency docket and that wasn't the proper way to decide cases. And I kind of share the implicit pessimism of the rest of the group that I don't think that the Callais case is going to have all that significant effect in taking cases off of that emergency or motions docket. The second thing that I wanted to bring out explicitly is the Supreme Court's attitude toward the lower courts, and in particular the Supreme Court's suspicion of the lower court's political decision making. And the Supreme Court itself, of course, gets a lot of flack and publicity for its political bent or its political makeup, but the 6 Republican appointees on the Supreme Court give it a fairly solid majority for the present time. But the Democrats make up a clear majority, about 60% of the lower courts, and will continue to make up a significant majority even after the end of the present administration. As long as that split continues, I suspect we're going to be likely to see a lot of the kinds of cases that are going to be pushed toward the emergency docket. You're going to have lower courts that are resisting Supreme Court rulings and deciding cases, or at least that are thought to be directly contrary to Supreme Court precedent, and the Supreme Court's going to have to step in and slap them down. It's not just the Bazelon right DC circuit of the late 70s. and it's no longer just the Ninth Circuit of the 80s, you're going to have, I think you're going to have this trend continue for quite a bit.
You know, stepping back, I think there's a few factors that are driving all of this that are bigger than the court itself. First of all, of course, the President of the United States has a lot that he wants to get done. He's a very active executive. And secondly, he's got a pretty strong belief, and it's the people around him, in a unitary executive theory that they want to press. Thirdly, you have the opposite party has no check anywhere else other than in the courts currently. And then finally, I think we're dealing with a situation in which there is a fundamental challenge that we're seeing across the board on a lot of the decision-making that's taking on two key features of the American government that I think have been in greater consensus than they are today. And that is, first, the consensus of the role in government that emanated from the New Deal, and secondly, the consensus that flowed post-Watergate. And both of those, I think, are being pulled on very strongly, and there are plenty of judges and plenty of people, therefore, who are seeking to oppose, and their only opposition route that they see in this environment is through the court system. And obviously, this president and his administration, I think, very much, therefore, are going to make sure that they try to fight to win, and where necessary, they take it up to the top, and it comes up in this emergency docket setting for the reasons that others have stated.
Anybody else? All right, I want to talk a little bit about something else that's gotten a fair amount of press over the summer, and that is the role of the dynamics among the justices. You know, even before the summer recess, we had the CASA decision in which Justice Barrett and Justice Jackson were very critical of each other. Justice Jackson had a very strongly worded dissent, and then in her opinion for the majority, Justice Barrett, you know, said essentially of Justice Sotomayor's main dissent, you know, the sort of conventional legal analysis, but, you know, let me criticize Justice Jackson's opinion. And then Justice Jackson had some dissents on the emergency docket over the summer, including one in which she accused the majority of playing Calvin ball. For those of you who are too young to know about Calvin and Hobbes, the cartoon in which the little boy Calvin plays with his stuffed tiger and essentially makes up the rules as he goes along. And so I guess my question is sort of, what does that say about the dynamics of the court? And is this kind of personal attack unusual? And I guess, you know, I just got Justice Kennedy's memoir last night, and he discusses Justice Scalia's dissent in Obergefell. And the first paragraph says, you know, I write separately to call attention to this court's threat to American democracy. So we had sort of big, high-level criticism, and then he also said, I would hide my head in a bag before joining the Kennedy opinion in a footnote. Justice Kennedy also said that right before Justice Scalia died in 2016, he visited Justice Kennedy in his chambers and said that he regretted the tone of that dissent. So, you know, what is this? Is this unusual, what we're seeing right now? And what does it mean for the justices and how they're getting along?
I mean, I'm halfway through Justice Barrett's book, and I'm going to take her at her word that she tries very hard to get along, and that it is much less acrimonious than those of us on the outside would like to project upon them. So,
I think there is something interesting about the sky is falling kind of attitude that the dissenters say. And I don't know whether there's something different about it now compared with what it was when Justice Scalia was writing his fiery dissents. I wonder if, as John said a minute ago, whether there's something in particular about the say, aggressiveness of the administration that brings out a kind of aggressiveness in its opponents, or vice versa. But the dissenting justices, Jackson in the Callais case, Sotomayor in the immigration cases over the summer, even Kagan in the partisan gerrymandering cases a few years ago, say, like Scalia did in the case that you quoted, that what the court's actions here are threats to democracy, and the courts in particular need to step up and defend the country from the executive, whereas the attitude, at least the attitude that justices like Barrett try to portray, is a much more restrained view of the rightful role of the federal courts. Whether the conservatives on the court consistently act in that kind of manner is a subject of considerable debate among a bunch of people. But I do think there is something significant in the attitudes that are portrayed, that the conservatives at least tend to state a position of federal courts are not here to solve all your problems, whereas liberals are, federal courts are your last hope against the desolation that's represented by the other branches.
I mean, I think the one thing that I would point out would maybe be the thing that you had started to highlight, Amy, which is that, you know, Justice Scalia was celebrated for his flair in his writing and often spoke at a colorful and loud volume when it came to his dissenting views, and many of his views were have been vindicated. I mean, I don't know anyone who hasn't thought carefully about Morrison v. Olson and that dissent, and I think that to the extent that there is colorful language on the opposite side of the court now, that speaks maybe more to the change in the center pole and how the balance of cases that are decided may weight in one direction more than the other now. And I think that Justice Jackson has always had a similar skill with the pen and flair to Justice Scalia's, and I think she may very well be the next, you know, great dissenter in that respect.
I think one of the things that makes the questions like this interesting is that to me, the most interesting disputes or debates or, you know, fights, if you must, on are intra-conservative kinds of things. And the coalitions in cases that you see are not the sort of typical ones. You know, Justice Thomas was recently at our law school, and he was talking about his time on the court it was the most stable court, 11 years without any personnel change, and I wasn't the only one who detected almost a kind of wistfulness for those days. But
I was there. I definitely got that too.
Is that the right word? Maybe wistfulness, a kind of like, and the affection that he had truly for the guy next to him, Justice Breyer, right, or Justice O'Connor, you described as a Renaissance woman, and some of these things take time to gel. So some of it, it can be that, but I think also what was different about that time, at least to say from the Scalia Chamber's perspective, is, are you going to be disappointed by Justice Kennedy or Justice O'Connor this term? It was very sort of, predictable in that sense. And I guess one hope that I have is that because there's more in play in different dimensions, that how to put it, that the recognition that you are kind of in a team sport, but that your team isn't always going to be the same team in order to have your views vindicated in a majority, can ameliorate some of that, and then they get into their routines a little bit. I don't know, though.
That seems like a good note to end on. So I think we'll move on to our lightning round. It's our sort of quasi-lightning round. It doesn't have to be like one sentence. But I'm going to ask each of our panelists to mention a petition for review, a case on the emergency docket, or even a trend that you're watching as the court starts on the first Monday in October. Kevin?
Uh-oh.
Yeah,
I
sorry,
thought it
you
was
sat
safe
closest
being
to
right
me.
next to you, yes.
Do we have to start on the other end?
No, that's okay. I'll go.
Okay.
So on the.
This is my law school professor mode here.
So I'm looking out for Second Amendment cases in particular, in part because of Justice Kavanaugh's opinion in a case called Snope that they did not hear. It's sort of like the opposite of the emergency docket, the idea of we see this is coming and we understand that we will need to decide this, but not
turtle
right
docket
now.
or
It's
something,
right.
yeah.
It's fitting, more like the motto, what you call
The
it,
tortoise?
the mascot.
Yeah.
The tortoise docket. And I think the Second Amendment issues are interesting in part because of the potential, how to put it, it's not quite methodological, but jurisprudential outlook is being refined among the justices in these Second Amendment cases. And unlike some of the things where they're responding, it seems that they're trying to, in some ways, control, calibrate, and modulate the pace of change and decision-making. And so I want to see what, in an area that they're in control of, how they use that.
Thank you.
There is another potentially important Section 2 of the Voting Rights Act case that could be granted, and if the Supreme Court doesn't take this one, whose name is Castor, it will have to take another one. The question is whether Section 2 of the Voting Rights Act, again, this section that has been used for more than 20 years to force states to create majority-minority districts, whether that section of the Voting Rights Act may be enforced through a private right of action, or instead whether enforcement by the Department of Justice is the only method. The Supreme Court has greatly tightened up the ability to sue, to enforce federal law through private lawsuits where Congress doesn't quite say that private people can bring lawsuits. Most of the time, of course, Congress says, here's what you may not do, and if you don't do it, here's what happens, or here's who can sue to enforce it. But sometimes Congress just writes a statute that says, don't do this, and then just sort of leaves the or else part blank. And in the early part of the 20th century, the court was relatively free in saying, well, if Congress hasn't created a remedy, then we're standing ready by to create a remedy that we think is going to make Congress's right fully enforced. And the court has not been nearly as generous in recent terms. The particularly noteworthy case within the last generation is a case called Alexander versus Sandoval, which all but said if Congress doesn't create and express private right of action, then there is no private right of action, government enforcement only. Section 2 of the Voting Rights Act is one of these cases that's in that category. It says states can't do this, or they have to do this, but it doesn't say who can sue to enforce that rule. Now, private plaintiffs have brought several cases, and a lot of the Section 2 cases that have been fully litigated have been initially brought by private parties. But the court has never said that that's okay, and the Eighth Circuit recently held that it's not. The Eighth Circuit created a circuit split in saying that there is no right to bring a private lawsuit to enforce Section 2 of the Voting Rights Act. As I say, other circuits do allow those kinds of suits, and I think the Supreme Court is going to find that situation intolerable. So unless the Supreme Court strikes down Section 2 in the Callais case, it will have to decide for the nation whether those suits can be brought privately or not.
Well, I'm following sort of two trends. I don't know that either of them are automatically going to be ripe for the emergency docket, or
That's fine.
In this term or not. But I
We like
think
the tortoise docket.
both of them are interesting. Obviously, in the first instance, as a former U.S. attorney, I'm interested in all the disputes around U.S. attorneys, and we know that obviously some of the appointments that have been made in ways that are being challenged. The Vacancy Reform Act and the other appointment statutes for United States attorneys basically set up a construct in which the Attorney General may appoint a United States attorney for a period of up to 120 days. The alternative then is generally that United States attorney, the court can then appoint a United States attorney. And the other way that you can have somebody in that place is an acting U.S. attorney. Generally, the acting U.S. attorney needs to be the first assistant and have been at least in that post for some, prior to the time that they're named as the acting U.S. attorney, or at least that probably was the consensus view prior to the recent litigation. Obviously, we have a case that is now at the Third Circuit in which a defendant brought a challenge to his indictment, claiming that the United States attorney for the District of New Jersey was unlawfully appointed, and therefore that his indictment should be dismissed. That case was decided by a district court judge in the Eastern District of Pennsylvania after the New Jersey federal judges recused themselves since they had appointed a United States attorney whom President Trump promptly fired. So the precedent that's going to be set in this Third Circuit decision will be interesting to watch, because if they were to uphold the district court's decision, they would be suggesting that the current United States attorney for the District of New Jersey is not lawfully holding the position, but that the indictment could nonetheless continue. So that's interesting in and of itself. What's interesting also is how and to what degree it may influence another indictment that you guys may have heard of involving a man by the name of James Comey. And in that case, of course, the United States Attorney's Office presented an indictment just last week charging Mr. Comey with 2 federal crimes. The question there presented, I think, is who presented to the grand jury? Was it the newly appointed United States Attorney acting alone, or was she joined by assistant United States attorneys in that presentment? And I raise that question only because if you follow the Eastern District of Pennsylvania's reasoning, the indictment would stand regardless of the fact that the United States Attorney, even if not holding the office validly in the court's view, the court obviously didn't dismiss the indictment, because the court basically said, look, it was presented by an assistant United States attorney. That assistant United States attorney is holding the office, serves at the direction of the Attorney General, was appointed pursuant to by the Attorney General of the United States, not the United States Attorney, and so therefore no problem with that particular indictment. What I'm interested in watching is whether we learn as to whether an assistant United States attorney was involved in the presentment of the indictment against James Comey or not. If they did, and the reasoning in the Eastern District of Pennsylvania court holds, or the Third Circuit, then presumably the indictment stands. Obviously, if the Third Circuit reverses the Eastern District of Pennsylvania and says that the current New Jersey U.S. Attorney holds the position validly, and therefore you can have successive appointments on an interim basis of United States attorneys, then obviously no problem for this most recent indictment in the Eastern District of Virginia. If, on the other hand, the current U.S. Attorney, who was the only person who presented it, and it's deemed that she is not lawfully holding that position, because I'm certain that a challenge will be raised, then the question is left with what happens when an indictment is returned after a presentment by a person in the grand jury on behalf of the government who wasn't validly holding the position. Obviously, I'm still in hypothetical land, because, of course, looking at grand jury presentments is an interesting topic. Courts generally don't like to look behind too much at what grand juries do. And what if, of course, and we can assume there's probable cause to support the indictment itself. And so does the fact that the individual in question may not have been properly there affect the rendering and the return and a finding of probable cause on the indictment? This is obviously most important and critical for the Justice Department because, as I understand it at least, and reported, the statute of limitations that may be applying here has probably already run as of today, and so their ability to present in another manner and supersede presumably would be compromised. So that's one issue that I'm watching pretty closely these days. The second issue that I think is worthy of watching, and that may come up sooner in my mind, is the question involving the deployment of National Guard troops in various locations around the country. I don't pretend to be a full expert on the Posse Comitatus Act of 1878, but there's obviously a distinction between National Guard troops being deployed to guard a federal facility and National Guard troops being used for domestic law enforcement purposes. And therein, I think, how in fact the troops are used and deployed will be one of the central questions for any of the challenges to the use of National Guard troops, as seemingly the President has announced he's directing be done.
Thank you. Joanne?
Yeah, something I'm interested in right now is summary reversals. So something that people might remember from a few years ago is the court used to issue summary reversals pretty frequently. There would be, on average, I think the stat is there were 7 or more per term on average for the first 15 years of the Roberts Court. And then in the past 4 terms, there have only been 1 summary reversal per term. So kind of just a huge drop-off. Actually thinking back to our discussion about the shadow docket and my comment about the court saying, oh, our decisions are precedential now, and if you know we think we're going to overrule something, you should be applying that, lower courts. That's actually in direct tension with a case that was summarily reversed, one of the summary reversal decisions from back like OT 2016, 2017, something like that. Bosse v. Oklahoma, a court had gotten ahead of the court and said, one of the lower courts had said, we think the Supreme Court is about to overrule X case, and so we're going to decide this case in front of us right now consistent with what we think the Supreme Court might do. And that was a summary reversal, and the court said, we overrule cases. Like, we don't get to guess at what we might do, and that apparently is no longer a thing that the court views to be unanimously true. So that there's a very interesting article, or forthcoming article by Calvis Gold, in the Columbia Law Review about this trend, and it speculates, offers a few different reasons that the court may have slowed down in issuing these summary reversals, one of which I think is maybe more plausible than the others, which is this kind of combination of forces between the number of votes needed for a summary reversal. Summary reversals is normally 6 votes, that's a lot of votes, and there are very few things that 6 members of the court necessarily agree on. And then the other cross-cutting tension is that the subject matter of the summary reversals in their heyday was very much focused on qualified immunity, basically grants of relief to people who are incarcerated, or decisions that were made at the expense of police officers was like a big theme of what the summary reversals were. And it could be that the judiciary has just become more conservative, or that the judiciary has learned its lesson from all of those summary reversals, and there no longer are a bunch of qualified immunity sumrevs to offer. The more recent sumrevs don't fit that theme. They have been more diverse in their subject matter, so that could be part of it. But I think it's quite interesting, and I think that watching the requests for summary reversals come in has been pretty interesting too. The summary reversal last term was of a decision from the Fourth Circuit. It was a Bivens case, which again was like a very normal fact pattern for sumrevs back in their heyday. The grant of a new Bivens-related cause of action, and the court sumrev just last term, a decision from the Fourth Circuit where the Fourth Circuit had basically found that a prisoner had a cause of action related to excessive force that he had suffered while he was in solitary confinement, and the sumrev said pretty quickly, no, you don't. And and immediately after that, the Maryland AG asked for a couple of sum revs in decisions authored by the same jurist from that same court. So I thought that was interesting, that there might be patterns or that people might be trying to lean on the sum revs and move more momentum in that direction once again. So we'll see how those come out.
Fascinating. Thank
One
you.
of the
Oh,
interesting
okay.
things about that idea, yeah, and certainly true, the Supreme Court has said over and over, we have the prerogative to overrule our own cases. You're not supposed to get out in front of us. But a lower court will be reversed on that ground only if it guesses wrong. So if you correctly predict that the Supreme Court's going to overturn the precedent, then you're going to be affirmed, although maybe with a don't do that again kind of thing. And that happened to the Pennsylvania Supreme Court some 20 years ago in one of the nude dancing cases, where it had a case that was on all fours with a case that the Supreme Court had decided a few years before. Pennsylvania Supreme Court reaches the opposite result on federal grounds, and the Supreme Court affirms because it says, yeah, our prior decision wasn't all that good.
The other thing you can think about when it comes to these district court decisions, particularly as it applies to Bivens, is a district court judge should always remember the following adage: the only person who has a Bivens claim is Mr. Bivens.
So we're watching some progeny of the JARC-C decision last June that dinged the SEC for imposing fines without a jury trial, right? There's a series of cases that are pending in 3 different circuit courts that test whether and how that case limits the ability of the Federal Communications Commission to impose forfeitures. And so 3 of the wireless carriers, and we're involved in the cases, but 3 of the carriers were hit with enormous forfeitures by the FCC in the previous administration, specious kind of aggressive readings of the statute that they allegedly violated, and then wild forfeitures that really the agency has not had a good track record of being clear about how it calculates forfeitures. The 3 recipients of those forfeiture orders went to their respective circuit courts and challenged it. AT&T's case went first. The 5th Circuit struck it down and said the FCC can't do this. The DC Circuit and the 2nd Circuit have Verizon and T-Mobile's cases. They decided the cases differently. There's still proceedings going on in some of the circuit courts, but I expect that question will make its way to the Supreme Court fairly soon, and it's just very interesting to see how that agency and other agencies in a post-JARC-C world are approaching and still defending their forfeiture abilities and their other authorities, when you might think that they would back off of that in a small government sort of world. They are, continuing to defend the prerogatives of the agencies to impose forfeitures. So that's one we're watching, and I think it's going to be up fairly, maybe not soon, but this term or soon.
Okay, Carrie.
Yeah, a couple cases on the religious freedom front to flag that are coming. One of them is Miller versus Civil Rights Division. This one feels familiar because it's another cake baker being asked to make a cake for a gay wedding and being told by the state that it has to do so. This time it's in California rather than Colorado, so there's an opportunity for the Supreme Court to go back and decide this on clearer grounds than maybe the Masterpiece Cake Shop one is, that relied to some extent on the fact that Colorado has been over and over discriminating against Christians in particular, and had a lot of evidence in the record on that front. So I think that'll be an interesting one to watch, and it kind of also fits into this pattern of our lower courts properly following what the Supreme Court has asked them to do in these areas. And then another on a similar religious freedom kind of issue was Doe's 1 and 2 versus Hochul. This has to do with New York's policy during COVID-19, which is that no religious examinations would even be entertained whatsoever, which seems to fly in the face of Title VII. So I think that would be interesting to see the court address that issue.
Fantastic. Oh, now it is time if you all have any questions. We have a mic here and a mic there. If you want to, okay.
Just a real quick one, and the tariff case, of course, brings this up, but to what extent does the court look at what's the practical impact of them trying to put the toothpaste back in the tube or unring the bell? I mean, it's one thing to do a tariff case when it's the first tariff, but now that so much time has gone by, or we had a similar issue in the docket cases where the Fifth Circuit clearly hesitated to strike down the law and deport 10 million kids. So they kicked the can down the road. But it's not a legal question, it's just a practical, how's the court look at that kind of stuff?
I mean, I'd be curious to hear what my co-panelists think, but I think that it might, based on things the court has said in other decisions, I think they would think that that's a Court of Federal Claims problem. And they would say, you know, if they decide that the tariffs are unlawful, all of these various businesses could go to the Court of Federal Claims and try to get refunds, and that would be someone else's problem. That's my current belief, but I'd be interested in what others
Yeah,
think.
I'm actually really interested in hearing what you have to say, too.
Yeah, I think that's what my understanding is procedurally, that's essentially what they would have to do in order to get a refund. I think the refund part of it is significant, obviously hundreds of billions of dollars, so there'll be a fiscal impact on this. I think the other practical reality is that this is a major tool of American foreign policy effectively. What the president has done is harness these economic tools. And it's an extension, obviously, of the sanctions regimes in a lot of ways, taking it to another level. And, you know, the court is often reluctant to make major changes that the president does that are broader than sort of any particular litigant in front of it. And so, you know, they can't be unmindful of it, but I can't speak for what any particular justice, how persuasive that's going to be for any particular justice, because of course there are other significant countervailing arguments here, as was pointed out in terms of summarizing the two sides. But of course, this is the nature of a vigorous executive branch. When the President of the United States moves fast, it often puts the court in a difficult spot to unring the bell.
All right, go to the other microphone.
It works. Hi, thank you for the discussion. I had a question regarding the Voting Rights Act. When analyzing the law, is the court going to just take a look at, can the court look at context, meaning one, the text of the law and the Constitution, and also just sort of history? If you look at this, the Voting Rights Act, you know, Section 2 authorizes Congress to enforce Section 1, which really has to do with being able to, you know, the states can't, and also the country can't prevent people from voting on account of race, I guess color and previous condition of servitude. It's not really there to populate the Congressional Black Caucus. But even if you don't think voting, having more blacks in government you could look around the country, it hasn't really proved that they actually look out for the people they supposedly govern. And also, you just look at the Voting Rights Act itself. 1 year later, the people of Massachusetts, who was 97% white, sent Ed Brooke, a black man, to the Senate. So it definitely demonstrates that blacks, even back in 1966, were willing to vote for a black person. So is that something that the courts would consider in analyzing the Voting Rights Act?
The overall answer is yes, that the Supreme Court does consider the history and general sort of societal context of the statute. The more specific answer is that seems to be what Justice Kavanaugh is particularly interested in. That his argument, at least that he's sketched out, he's not taken a definitive position on it, but what he's suggesting might be the case is that the Voting Rights Act, and Section 2 in particular, had been constitutional because it was a congruent and proportional response to a problem that existed in the country around the time that the statute was passed. But that in the 25 years since, far more than 25 years since the Voting Rights Act was amended, the situation of racial discrimination in voting has changed so significantly that the amendment to Section 2 is no longer congruent and proportional to the constitutional violations that are now occurring. And the parallel would be to Shelby County versus Holder, a case the court decided about 10 years ago, where the court said that Section 4's preclearance test, which states have to preclear their laws, was unconstitutional, even though it didn't used to be unconstitutional. It has become unconstitutional because of changes in American society. So I certainly think that it's possible, indeed likely, that the Supreme Court will engage a similar kind of analysis with regard to the Callais case.
Thank you.
Can I add something to that? So
You get the last word.
oh, that's a lot of pressure. Okay. So maybe two short things then. So one thing I'd flag is that, I mean, I think that something that's a little uncomfortable in the Shelby County line of reasoning, and that I think many people feel a little bit skeptical of, is this idea that Congress could enact a statute that was okay at one time, and then instead of Congress being the one to decide that the statute had served its purpose and was done, that instead the court would say, okay, that's enough, Congress, you're going to have to try again with that. Normally the court doesn't go about saying that a statute has expired, suddenly. Findings are findings, and when Congress makes findings to support the meaning of the statute, that's the law, and the Supreme Court just interprets it. It doesn't get to say, that was good enough then, but it's not good enough now. Of course, the court did say that in Shelby County, but that was a bit unusual, and I think that the court might be reluctant to say that type of thing again. The other thing that I would say is that Section 2 of the Voting Rights Act, to a large extent, kind of has an internal self-limiting principle, which is that if we are at a point in society in which we're no longer segregated, such that you could draw a district where you're drawing a circle around all the black people that live within a particular state, then Section 2 kind of wouldn't have any work to do. There wouldn't be a world in which you could draw an opportunity district in which minorities would be able to elect a candidate of their choice, because minorities would be spread evenly throughout the state or throughout the voting district. And so there's kind of one of the successes, I think you could say, that in Congress's original design of the statute was that as our society became more integrated, you would not have a world in which courts would be saying you need to draw another opportunity district for minorities.
All right, it is now 2:32. I'm sorry, I don't think we're going to
Just quick question. What do they think the court's going to do on birthright citizenship?
Oh, that is a good question. Yes.
Thank you.
Yes,
Of course
sir.
I have good questions. The search
Yes.
petition's pending, and I'm sure it'll be granted.
Yes.
What does the panel think that'll come out?
Is there any, yeah.
I haven't given it enough thought.
I would be terribly surprised if the court agreed with the administration's argument on the merits of the birthright citizenship case.
To add to that, the reason that one would be surprised is just given the arguments in the injunction case and the things that came through there, it's just really hard from a tactical perspective to even think about how you would compose a majority. But that is purely descriptive, looking at it and saying, yeah, as soon as that's just hard to see the administration prevailing.
All right, please join me in thanking our wonderful panel. And thank you for coming.